Hi, my name is Kent Oldham. I am the head of customer data governance here at InfoTrust. And today we're going to talk to you a little bit about CCPA and frequently asked questions that we get a lot from our clients. And I'm joined here today by Lucas Long.
Thank you, Kent. As mentioned, my name is Lucas. I'm our product manager for Tag Inspector. Tag Inspector, it's a tag auditing and monitoring platform. So we're really looking at the data being collected by marketing, advertising, analytics platforms across clients' websites across the globe. And as a function of that, we're doing a lot of work around privacy, helping organizations understand what's collected, make sure that it's compliant under the various different laws and regulations. And so through a lot of that work and working with hundreds of organizations in doing that, become a so-called expert on topics
You're
such
definitely
as
an expert. That's why you're answering the questions.
such
Yes.
as CCPA, the California Consumer Privacy Act, GDPR, e-privacy directives, and the upcoming e-privacy regulation, which maybe will pass.
Perfect. Now, before we jump into some of the questions, real quick legal disclaimer. We're not a legal organization. We're not lawyers. Yes, you're incredibly knowledgeable. Thank you for joining us here today. But please do refer to your own legal department when making the final decisions in terms of how you're going to interpret these. Ready to jump into the questions?
Absolutely.
All right.
Really a combination of items, I guess. Generally, users have a more thoughtful, I guess, about their privacy and more aware of different privacy issues and breaches that are happening. Specifically mentioned within the introduction to the CCPA was the Cambridge Analytica scandal.
Yeah.
So obviously, when topics such as that come up, it's very prevalent in the news. People become very aware of, or more aware, I guess, of what information is being collected about them, how it's being used, what organizations are doing with their information, and how some of those uses could be potentially nefarious or a little bit scary for users. So that really drove the national consciousness around privacy, and then hence, as a result, we're seeing legislation such as CCPA.
Okay. Real quick, what does CCPA stand for before we really dive into it? Just keep using the acronym.
Yeah, the California Consumer Privacy Act. It's basically an affording of specific privacy rights to residents of California. So it gives them some specific rights, which we'll talk about with respect to the information that they are providing to organizations, and then protections for that information. Yeah, so CCPA, unlike GDPR or some of the other privacy regulations that organizations might be aware of, doesn't apply to everybody. It's only to organizations that meet specific thresholds. So those thresholds, there's one of three different possibilities or thresholds that an organization can meet. The first one is that if they have annual revenue above $25 million. Second one being if they buy, receive, sell, or share personal information of more than 50,000 consumers over the course of a year. And then the third is if more than 50% of their annual revenue is derived from the selling of consumers' personal information. So small businesses potentially would not have to fall under the scope of CCPA, but it is definitely meant to cover any large, medium-sized business.
Okay. Say I'm a business and I'm located in Cincinnati, New York, but I get a lot of traffic from California. Am I still subject to this and all the processes that go with it?
It would be. So the rights are afforded to residents of California. So if your organization meets any of those general thresholds, and they are holistic thresholds, it's not only specific to revenue generated from those California residents, then you need to have those protections in place for those California residents, and action could be potentially brought against you if you're in violation of any of the stipulations of the law.
Okay, so I guess one of the key takeaways is it really doesn't matter that I'm not physically located in California.
Correct.
But if I have Californians, which almost by definition, if I'm open for business, I may have Californians coming to my site.
Yep, absolutely.
Okay.
No, it'd be more broad. So yeah, any of those requirements, as long as you're broadly meeting those requirements. Yeah, so excellent question.
And we might even want to talk about PCI, PII before we even get into that.
Yeah, it's important to touch on a few of the different definitions that we hear just as you're working with different marketing, advertising, any type of platforms. So the first designation, really there's three different types that you're going to hear. So you're going to hear either PII data, which is what traditionally you're going to see in the terms associated with different platforms that, for Google Analytics as an example, you're not allowed to collect PII, so personally identifiable information. That's your traditional values such as like email, name, address, social security number. Those things are PII data. The second definition that organizations have likely heard is personal data. That is a reference from GDPR, which is the General Data Protection Regulation, which applies to citizens or residents of the European Union. And that has a little bit more defined, or I guess narrow scope of the definition. It's any data point that can be used to directly or indirectly identify a natural person. For the CCPA, the definition or the wording that you'll hear is personal information. That is a very large or very wide scope of the definition. So it's any data point that can be associated with an individual or a household. So examples of that would be even like a unique anonymous identifiers, such as a cookie ID that is unique to a particular device, which would be considered specific to an individual user. Or something like your IP address, which is going to be specific to a device which can be associated with a household. So it's a much broader scope of a definition for personal information as defined in the CCPA.
And just to expand on that, like how broad can that possibly go? Could it be that I have blue eyes?
It would depend. It would depend if it can be associated with something like that, a unique anonymous identifier. If all those data points are tied together in one data set that is associated with you as a user, then that could be considered personal information. Just generally, blue eyes would not be, because that would apply to both you and I.
Right.
So it's not specifically associated with you as a specific user.
Okay. As my understanding is, they seem to be fairly significant. Can you explain what those are?
Yeah, so the user rights under the CCPA are significant, yes, not nearly as stringent as what we've seen with the European regulations, for example. But the first one is just a right to transparency. So you as a consumer have a right to understand what personal information is being collected from you and then sold. Who is it being sold to, and then how is it being used? So there are some specific stipulations that an organization must follow in order to be able to make sure that those transparency requirements are upheld. The second right that's afforded to users is that they have a right to request deletion of any personal information that you have associated with them. They also have a right to opt out of the sale of any of that personal information. And then they have a right to request access to any personal information that you have. So you would need to provide that to them. Kind of bundled up under all of these things is the right to not be discriminated against by the offering or the pricing that is for their execution of any of those rights. Yeah, so there's quite a few. For the really granular specifics in terms of the privacy notice, one of the things, we do have a few resources that are linked within the description for this video. One of those is a handout that actually outlines all of the specific notice requirements. So check that out. Just real quick though, in terms of the requirements for like disclosure at or before the collection of that information, users need to be able to access the categories of personal information. So the CCPA has some defined categories that different types of data fall into. So they need to the user has a right to have access to or to be able to view what categories of information are being collected, the purpose that each of those categories is being used for, so how their information is being used, and then finally need to be notified of any additional categories or any information that's going to be collected after, maybe potentially later in their relationship or dealings with the business.
Can you give us an idea of what like some of those categories of personal information, like give us an example of what a category would be?
Yeah, so one of the categories, just as a general example, would be any like electronic data. So things that, such as those cookie IDs, an IP address, all of those things roll up into one single category. So CCPA penalties are, again, a little interesting. There are maximum dollar amounts that are assigned based for individual violations. Now, an individual violation is the improper collection, sale, use of specific data points. So the penalties are up to $2,500 per violation for an unintentional violation, and then up to $7,500 for an intentional violation. Now, that per violation is notable because each case or each instance of those violations. So if an organization, for example, is collecting and selling some piece of personal information for 100 different users, so they're collecting and selling it from me, from you, and those transparency requirements are not being met, or there is no mechanism for me to opt out of that sale, for example, that would be an individual violation with respect to my personal data, as well as it would be a separate one with respect to yours. So those fines and those penalties can really compound quite a bit and pretty quickly, especially when we're talking about really large organizations.
Now, isn't there a bit of a twist too in terms of individual consumers being able to act on this and not just necessarily the government or attorney generals?
There is. So those penalties can be enacted by the Attorney General of the state of California. Individuals have a private right to action with respect to any breaches that happen of data. So one of the things that's also kind of in place here is that it puts larger penalties and a larger onus for organizations to keep personal information that they have stored and collected private, and have the proper security measures in place so they're not getting hacked and that information isn't being stolen. So in the case of a breach happening, individuals have a private right to action. So you can then potentially see some class action lawsuits around hacking incidents within an organization. And it's actually interesting that the first action brought forth naming CCPA is actually that exact case. So the intent between both is relatively similar. Both are in place in order to provide more privacy rights to individuals. Where they differ is that the GDPR is much more comprehensive, as well as provide some additional rights above and beyond CCPA. Now, in the same, or kind of on the flip side of that, the CCPA is much more broader in its definition of personal information. Now, for GDPR, there are additional requirements for what they're considering personal data, for users' consent and having a legal basis for processing of that information. So there's more requirements for the organization just for the collection and the use of any of that personal data.
Is that why we're seeing all the cookie banners if we visit sites
Yeah,
that are not
absolutely.
necessarily US based?
Yep.
Okay.
Consent banners in general, yes. Now, those are also in place because of some of the e-privacy directives that are in place across Europe and the e-privacy regulation that's being worked on right now. But yes, that's why you would see a lot of those banners. Now, while there are more requirements for the organization with respect to the collection, processing, the use of data in the EU, the CCPA is more so just covering a little bit more extreme uses, I guess. It still provides users that transparency, but as opposed to having the ability to opt out of the collection or processing of all of your personal data, it only refers to the opt-out of the sale of your personal information. So today we're sitting here, February 2020.
Important to know.
So the law went into effect on January 1 of 2020. Now, there is a process still ongoing where updates are being made. Regulations are changing within it, and there's actually still, right now, an open period for feedback on some of the new proposed changes. Those must be finalized by July 1 of this year. In the current kind of situation that we're in, the requirements are there as currently written, but an organization cannot face action from the state of California until that July 1 date. Now, it is important to note that private right of action for breaches is currently live and active.
Which is why we saw the one
Which
that
is
already
exactly.
happened.
Yep. Which is why we saw the lawsuit at the end of January, where an action has been brought, private action naming CCPA for a breach of personal information. Correct. Yeah, so I mean, if we think about the actual language within the law, right? We're talking about sale of personal information, sharing of personal information, as well as breach. So who is it that's storing that information? Now, the CCPA, unfortunately, does not go into as much detail as GDPR with respect to processors and controllers and all of that. But we can think of who would be in violation of the law as it's written. So if something is breached, who is it that owns that data, basically? For something like the sale, who is it that is getting some sort of business value from the sale of that information?
Okay.
So with respect to agencies, when we talk about agencies that maybe design or develop websites for an organization, they're not the ones actually collecting, storing, saving, selling any of that information. So it really is that end organization that is the one collecting, selling, storing, all of that, that's going to be the ones that are liable.
Got it. Now, if they sell to somebody who sells, how far does that go in terms of accountability?
Yeah, so it's actually interesting in the case of like an opt-out request or a deletion request. It is the responsibility of the organization that is receiving that deletion request to ensure that those pieces of personal information are removed and deleted all the way down the line.
Wow.
So any remnants of that personal information, whoever has it needs to, it extends for the life.
So just to kind of build on kind of that, where does accountability lie? So say I have a website that links out to something else, like I want to get a lease for a car, or I want to get a price quote or whatever, and so they're asking information. So it's not me doing that, but I link out to another site. Who's really accountable in that kind of context?
Yeah, again, it's going to go back to when we think about who is it that's collecting, who is it that's potentially selling that personal information. Now, there are a lot of kind of carve-outs within the law for if you are collecting or using personal information for purposes of carrying out your business activity. So, for example, obviously, me as a user, if I'm purchasing something from a website and I'm inputting my credit card information, name, all of that, all personal information, but I can't request that organization to delete my information immediately because they need it in order to process that transaction.
Got it.
So that's where some of those types of scenarios, while you might be using a third party, they're the ones collecting it. Yes, a user would need to kind of opt in, but in those cases, that is the purpose of the business activity. So the information is going to have kind of some different requirements there.
All right, if I am personally not asking for what you described as PII earlier, but there are some, let's call it analytics on my site that are tracking me as an individual, does that fall within the scope of PI and within the scope of this? Does that?
Yeah, so I mean, if we think back to the definition, the differentiation between the definitions, right? So personally identifiable information, so your clear text stuff like email, name, versus personal information. So any data point that can be associated with an individual or a household. So for analytics, in every single hit that's collected by something like Google Analytics, you're collecting a client ID, which is a unique anonymous identifier for that particular user, for that particular device. That is going to fall under the definition of personal information under CCPA. So for something like a deletion request, you would need to be able to delete that, or access, you need to be able to provide that piece of information along with anything that's associated with it. So for analytics, that could potentially include any like purchase information, event information, products viewed, all of those different things that you're associating with that user would again fall under that definition, because due to that client ID, you're able to associate all those different things with that individual.
Got it. So it's really all tied to that client ID. That
Yep.
makes perfect sense.
I think it's really important, and where we see success when we're working with organizations and when it's a cross-functional effort. So the requirements, or what I like to call the rules of the game that everyone's playing within, need to be defined by legal. Some legal groups might be comfortable with a little, more risk, I guess, than others. So the individual laws, and like we mentioned before, consult your legal departments before making any decisions. Legal ultimately is going to tell you what are you allowed to do. Now, the legal requirements, though, need to kind of be translated into the business side, which is where a lot of the work that we're doing around data governance with InfoTrust Tag Inspector kind of comes in. But that can also be a function of the marketing group within an organization. They're going to understand what are the goals of our website, what are we doing on our website, what are the different platforms that are going to be in use, how are we using them, what data is collected, how is that data being used. So they play a pivotal role in that piece to be able to define business objectives and then make sure that those goals are met within the kind of rules as laid out by legal. IT comes in because they're going to be the ones that are actually setting up that architecture. So making sure that there are technical safeguards in place or mechanisms in place for users to be able to opt out, have that information deleted, be able to pull down information, personal information when a request happens, those sorts of things. So all of those teams need to be really working together as a cross-functional group in order to be successful.
Kind of an additional question to that. How do you think about senior management support when it comes to these kind of efforts?
Critical. Yeah, nothing happens without senior management support at the end of the day.
Okay.
So, especially for large efforts like this, where there is going to need to be some investment to make sure that things are happening as they are required to be, as well as the fact that that investment's going to have to happen across multiple teams. Like we just talked about, there's legal resources that need to be used, there's IT resources, and without senior leadership, there's really no chance of that happening.
So I am one of these organizations. I'm going through this process, and I have third-party partners who handle some data on my behalf.
Yeah.
What guidance or what am I holding them accountable for? What are your thoughts on that?
Yeah, I mean, you really need to be understanding what information are you sharing with them. Look into the contracts that you have with those third-party providers. Make sure that there is a mechanism for you to be able to carry out those deletion requests or access requests with those different third parties. And yeah, make sure that they have the proper protections in place to keep the personal information that you're responsible for safe. No breaches and things of that nature.
Tell me about your definition of third parties. Is it fairly broad? Does it include people who provide tags? Is it literally just people that I'm asking to process data for me? Like, how broad is it?
When I'm thinking about like really a holistic governance kind of policy and process, it is pretty broad.
Yep.
It's anyone that I'm sharing information with or anyone that I'm using and storing my information with. So it would be rather broad in that sense. Excellent question. One of the things, well, a couple of different ways in which we go about it. One, I'd be remiss if I did not say that you could use a tag auditing platform such as Tag Inspector to be able to really view the information that's being collected and use its foundation to really go through and classify all that information. As an individual, kind of directly with the vendor that you're working with, you should be able to request and ask them, hey, what information are you collecting? Are you considering any of this personal information? And they should provide that to you. They should already have documentation realistically that explains any type of implications that information they're collecting that you could have with respect to different privacy laws. And then ultimately also just looking within the platform, right? If you're working with a third party, you ultimately should be the owners and controllers of that information. If not, then you need to look at your relationships with some of those different third parties. But looking within those different tools, understanding even from your business use case, what are we collecting? Why are we collecting it? What is it? To be able to answer those kinds of questions.
Which kind of ties back into the fact why we really think it should be functional, because
yeah, absolutely.
There's all different owners of what the activity systems that are happening on those sites and what they're collecting.
Yep, absolutely.
Makes sense. So far we've only been talking about California. We have mentioned other regulations, but as we think about specifically focusing on the U.S., what direction are other states going? Is this a trend? Is this a one-off?
Yeah, I mean, it definitely is. As mentioned before with the Cambridge Analytica scandal, it became a part of the national consciousness of just what information is collected and just privacy. I think people are generally now more aware. Now, does everybody care? Probably not.
Yeah.
But people are at least more aware and I think a little bit worried about what information is being collected, who could potentially have access to it, how is it being used. So as the tide rises, I guess in terms of awareness and concern, laws then follow. So we're seeing a number of states that are introducing legislation similar to CCPA, and as much as many large tech companies are trying to fight against it, there's also eventually at some point it reaches a critical mass where federally something needs to happen. We're seeing regulations go into place all over the world. Obviously, Europe being the kind of first movers in that sense, but a number of regulations go into effect even in places like Brazil later this year, as an example. So we're seeing a general global wave that I'm sure will at some point crash on the American shores. Yeah, I think at some point, as more states pass individual requirements, that yes, it becomes almost a requirement. Because if a storefront or an e-commerce web store in the United States, if they're having to follow different requirements for users from California, for users from Illinois, for users from Florida, it becomes way too arduous for businesses. Ultimately, what do we want to do is optimize everything and make everything as easy as possible for businesses to grow and thrive. So as that happens, as more requirements come into place, there almost has to be some sort of a federal response or a federal bill to just harmonize everything.
It's one of the rare times we actually hear business saying, hey, federal government would like some help, I think.
Yeah, I think one of the things, kind of harkening back to the question on who does this apply to, and tying that together with more states introducing and potential for federal law, it's becoming an expectation of users that you're putting privacy first, that you're taking care of the information that they're giving you, and that you're not collecting things that feel creepy without their knowledge. So really implementing, even if you don't meet the thresholds for CCPA, or even if you aren't doing business with any users in California, know that these different types of requirements are coming. The requirements as laid out within the CCPA are fairly minimal, as mentioned, especially with when compared to the European requirements. So it's a good idea to start putting some of these principles in place and really putting privacy by design as kind of at the forefront of your organization.
I love that term.
And taking more care of, well, just data governance in general. Understand what information is being collected, how it's used, where it's used, be able to provide that transparency to users. Otherwise, users are going to kind of pass by you, and you'll kind of erode that trust with them.
All right, perfect. Well, thank you for all your great insights. Sincerely appreciate it. If you guys would like to get any more information from us, you can reach out to either Lucas or myself, or very generally to InfoTrust. We appreciate your time, and we'll talk to you soon.